That
12 is a very old matter.
whole matter, but two analogous matter, exactly, my lord, in one case, my lord, two different orders are passed.
Oh, 12 is 23. 12 is not old matter. I
So
thought,
these two matters may come up along with that matter after.
what are the two matters?
These are same matter, my lord, royalty.
You have given the number.
No, Papa.
Sri GN Sahola Learned Senior Forest has been informed. Yes.
Yes, we have it.
Sri GN Sahola Learned Senior Council for the petitioner has submitted that there are two analogous matters being WPC so and so, so and so. Full stop para. Accordingly, this matter is adjourned to be listed along with WPC so and so, so and so for hearing. Give the numbers, please. Three, R.R. Gogoi, Learned Standing Council Forest is present.
Item number 9, my.
Yes.
So I want to withdraw this.
State of West Bengal.
Yes. Regarding passing, my lord, passing of a complaint,
Okay.
but already matter have been covered with the cell.
Who's for the other side?
So I'm for number 1.
Okay. Sri T.J. Mahanta, Senior Council submits that there are instructions not to press this writ petition. Sri, what is your name?
PS deck.
Sri B.S. Deka, Learned Council for the respondent number 1, and Sri N. Das, Learned State Council. Yes, Learned State Council, N. Das, Learned State Council for State of Assam are present. Para. Writ petition is dismissed on withdrawal. Who is with you, Mr. Mahanta?
My lord, SP Gogoi.
No, A. Borua, is he there in the court?
Today is not.
Today is not in. Okay, now like take for the petitioner. Huh?
Keep it up.
Yeah, please, Lordship. I beg to mention item number 10.
10, yes.
Yes, sir. I'm appearing on behalf of Mr. Eka Kotikor. And my senior, he is out of station today.
22 matter. Have you informed the other side?
Yes, yes, Lord.
Okay. On a request made on behalf of Sri A. Kakoti, Learned Council for the respondent number 5, matter is adjourned by a week. Yes,
Lordship, the matter may be taken up to 2 weeks.
by 2 weeks.
Maybe, sir. Lordship, with the concern address, I like to mention item 7 euro. Yesterday, after the adjournment, Dr. Saraf,
Why do you want adjournment?
Lordship, Dr. Saraf has got some personal difficulty.
On a request made on behalf of Dr. Saraf, Learned Senior Council for the petitioner, matter is adjourned by 2 weeks.
Public. Lordship, they intended.
Interim order passed earlier to continue till the next date of listing.
Public.
Yeah, Lordship, I beg to mention,
Urgent listing, when?
17th, maybe, or
What is the urgency?
I think the matter is pending here, Honorable High Court. And we can filing several cases in the court trial court. So,
What is the urgency? Not a new matter,
nothing more. And
23 matter.
interim is the favor of
Here for the respondent. When was it last listed?
last 10:30, 10:03.
10-3? 25. What was the order passed on that day?
The time the petitioner didn't found the respondent address for it.
Okay, next Wednesday. Not this Wednesday, next Wednesday. Give the date. That will be what? 23rd.
May I please?
Yes.
Item number 11, Lord.
Yes.
Kindly the matter may be taken up after 2 weeks. Yesterday we have served the.
That is okay, but why do you want adjournment 22 matter?
Lordship, my senior is not available.
Yes, Mrs. On a request made on behalf of the petitioner, matter is adjourned by 2 weeks. 11.
Deeply already.
Lordship, with the consent of the other side, I beg to mention item number 5.
5. Yes.
Lordship, we have submitted other adjournment slip yesterday
It's a 2016 matter, madam.
for today.
We are in 2025.
My senior is out of station.
We can accommodate you for a 1 or 2 days. 16 matters we cannot adjourn. When can you do?
But next week,
Next Monday we are fixing this matter. A prayer for adjournment has been made on behalf of the petitioner. Full stop. However, considering that this matter is pending since the year 2016, a slight adjournment is granted, directing listing of this matter for hearing on Monday next date. Yes. Yes, madam.
One land acquisition matter with urgent in nature, and that was filed on 2024, Lordship. For admission, it may be listed on FICAP,
When was it last listed?
10/3/25.
10-3. What was the order passed?
After 3 weeks for filing a reply.
You are for the petitioner.
Yes,
What is the subject matter?
land acquisition regarding ring road. in-
No, what is your claim?
My claim is that the authority, without following due process of law, as per.
That is not an urgent thing. Okay, Friday. Since you're mentioning Friday, okay.
Okay.
Friday, there may be some, okay, no problem. Okay, Friday.
Item 1. Please, your lordship.
Yes.
Here, my conveyance and good has been seized by the respondent authority, your lordship. In transit, they issue MOV 2 on 25th June 2025, your lordship. Page 25 is MOV 2.
It is notice is yet to be issued, Mr. Chaudhary.
Yes. Lordship.
You are supposed to have instructions.
Yes, I have the.
We'll do one thing, we'll issue a notice, short notice. Can you file an affidavit or can it be disposed of on the basis of the instructions?
Affidavit will be required.
Because let them have a copy of your instructions
Yes.
in the way of an affidavit. And at least they can file their response. You are Mr. Jain.
Sony, your lordship. Mr. Sony.
Sony. Okay.
Mr. Jain, Miss Jain is my AOR, your lordship. Even we are ready to pay tax penalty amount, your lordship.
Okay, let
Area
us
bill-
we'll issue notice at this stage.
Only may I request, subject to convince my lord. Here the goods are raw tobacco. It's perishable good, your lordship. Since
We'll
20.
issue a short notice, 2 weeks notice.
Otherwise, what happened? It's raw tobacco. We will lost, your lordship, everything, because on 25th,
We'll issue,
25th
we'll issue a short notice, 2 weeks
Ne-
notice.
not next week, your lordship. Only reason that otherwise we will suffer a huge loss.
Sony, he needs to file an affidavit. 2 weeks is a very less time. 2 weeks we are guaranteeing.
Only it is perishable good. Therefore, your lordship.
Understood, understood. You had moved this on 10/7, just before the vacation.
Please, your lordship, but this honorable court, it is matter is kept only for verifying the weight amount. As per the e-way bill, it is.
Yes, what do you
15
say on this?
Lordship, there are lots of discrepancy. Number one, as per the.
Okay, file affidavit.
Yes.
Heard 3 MM Sunil Learned Counsel appearing online for the petitioner. Full stop. The challenge is against the seizure of 15,000 kilogram bracket approx of unmanufactured tobacco dispatched. Full stop. The seizure was made while the goods were in transit. Full stop. Para. This court, wide order dated 10/7/2025, had directed Sri B. Chaudhary, Learned Standing Counsel, Finance Taxation Department, to obtain instructions pursuant to which certain instructions have been received. Full stop. Sri Chaudhary, the Learned Standing Counsel, has submitted that as per the instructions, there are discrepancies which he would like to place on record by way of an affidavit. Para, let notice be issued, returnable by an affidavit. At this stage, the Learned Counsel for the petitioner has expressed urgency as the goods in question are perishable in nature. Para, let notice be issued, returnable by 2 weeks. Returnable, or we give a date. When
Any
will
date
it-
subject to convince my lord.
Oh,
Any shorter date
returnable on 30th of July.
or meanwhile the stay may be continued. They will not
We'll
initiate.
continue, don't worry. Sri Chaudhary, B. Chaudhary, Learned Standing Counsel accepts notice on behalf of both the respondents. Copies have already been served upon you.
Please, your lordship.
Okay. The interim order passed earlier to continue till the next date of listing.
Or may I suggest if meanwhile they may be served advance copy, we will solve their discrepancy or move one application to pay tax and penalty subject to satisfaction other side, your lordship, then issue will be over, your lordship.
There is no restriction for you to file application. You file, they'll consider.
Or this may be observed, it will be helpful, your lordship.
If you have, we have not even filed, you file it. If you file, we'll make an observation, okay?
Please, or meanwhile, they may be some advance copy of reply. So we on next day we will prepare, your lordship.
Let us see, 2 weeks, try to give an advance copy.
Absolutely, absolutely.
Okay. Yes, next.
I'm grateful to highly obliged. May I take leave, your lordship?
Yes, please.
Item 2.
Lordship, before my learned friend starts, Lordship, in this case, our senior government advocate Tina will appear, Lordship. He is praying for a little accommodation, time being or day
IA
after,
for what? IA for?
for vacation of that interim order, Lord.
You are for the writ petitioner,
Mal.
opposite party.
Mal.
And IA is by whom?
Respondent number 4 and respondent number 10.
The private respondent. Yes.
Respondent number is the 10 is the private respondent, number 4 is Malad Chief Engineer PWD.
Okay. Both the department and the private respondent are praying for vacation of the state.
Yes.
I would like to press it today or some other day.
Lordship, he's make a request to me to make a prayer before Lordship for time being or day after tomorrow.
No. As whatever suits you. If it is urgent, we can have it after some time.
Malad,
After a while, then.
Lord.
What is the stay?
Lordship,
we are
what
not, we are in a, their allegation is that we are in a government land and they want to evict us because they are having a project over that land. And they
Which place?
Malad, it is in Rupoi, Uttar Etapara, Uttar Herapati. It is in Lagoon, Malad. It is in Kundagat,
in Nagaon district.
Nagaon district.
I've been told that because of construction of a bridge, Lordship, those the lands are required, Lordship, where it's
Okay.
the government land and they are
You wait for a while. Let Mr. Nath come.
Lord.
Okay. 2 IAs are there or 1 IA? 2 IAs. One by you, one by the state department. Okay.
Item 3.
My lord, kindly pass over the matter for the time being, my lord. My lord, MSP Das will appear in this matter, my lord, and she is on late.
Who will
After
appear?
some time, my lord,
Who will appear?
P Das.
16 matter.
Das.
What is the matter?
Well, my
Chakraborty?
lord, the 3 petitioners, they were tenants under the earlier, my lord, Guwahati Madrasa High School. The tenancy agreement were executed since 1969, 1971, and it's still continuing. Suddenly, my lord, a notice has been issued alleging the petitioners to be unauthorized occupant and thereby directed for eviction. Lordship knows, my lord, in respect of unauthorized occupants, Assam Public Premises Unauthorized Occupants Act will be applicable. But that act has no application in this case because, my lord, they were tenants. They have got tenancy agreements in their favor executed prior to provincialization of the madrasas. In fact, my lord, the Act, Madrasa Provincialization Act, as per the Section 10, land and building, even after provincialization, will vest in the madrasa only, my lord. So therefore, my lord, the case of the petitioner is that they cannot be evicted without following the process of law, which is, my lord, the provisions under
Do you have a landlord-tenant relationship with the madrasa?
Yes, my lord.
By virtue of what? Atonement or what?
By virtue of tenancy agreement, my lord.
With whom?
With the school managing committee prior to its provincialization.
Prior to its provincialization.
And Section 10 of the
Now, after provincialization, who's the owner of the property?
is the government, but their Section 10 says there is a protection, my lord. Lordship, kindly turn. If your lordship having this book, my
Yes,
lord,
what does it say?
this is the Assam Madrasa Education Provincialization Act of 1995. But Section 10 of this Act.
No, we are not on the aspect of provincialization. We are on the aspect of
Yes, that's what, my lord.
landlord-tenant relationship.
Yes, that's what. My Section 10 kindly be seen, my lord.
Please.
Section 10.
Yes. Page, which page?
Lordship, if this lordship is holding
Same
this
page.
book, my lord, it is page 398.
Yes.
Vesting of Section 10, my lord. Vesting of land, building, and other properties. The land, buildings, or any other property owned by any senior madrasa, title madrasa, or Arabic college, whose employees' services are provincialized as per provincialization of this Act, shall continue to be owned by the respective senior madrasa, title madrasa, or Arabic college. So basically, my lord, irrespective of the provincialization, Section 10 protects that the land will be and building will be owned by the madrasa. And Lordship, that Madrasa Act has been repealed by a subsequent act.
Hmm.
Irrespective of that, my lord, any act done has been protected. A perpetuity. That is the repealing act of 2020, my lord.
Hmm.
Lordship, kindly come to the next page. 2. Notwithstanding such repeal of the act as mentioned in subsection 1 above, anything done or any action taken under the act or repeal before the date of commencement of this repealing act shall be deemed to have been validly done or taken under repealed act.
Hmm.
So,
What does it save?
my lord,
What is the extent of this saving clause?
my lord, my contention is
Things
that
done or which have been
because,
anything
my lord,
done or
these
any action
tenancies,
taken. Yes.
tenancies were continued since 1969. At that time, the school was not provincialized. In 1995, by this provincialization act, it was provincial. The services were provincialized, but the buildings and other properties, it continued with the madrasa. Therefore, by the school managing committee executed these tenancy agreements. These are still in force. In the event the petitioners being tenant,
Still in force? What, in sufferance or what? How is it still in force? Is it renewed
we
from time
are,
to...
we are regularly paying the rent.
No, no, it is renewed from time to time.
Yes, 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 ma'am.
Renewed.
Yeah, thereafter we are paying, depositing in the court, my lord.
That is not a renewal. That is tenants by sufferance.
But thing is that in that event, the
We
petitioners
have
are to be
volunteered to pay
evicted.
the rent. You will, we are not saying that the relationship has extinguished.
Yes.
But you have to show some, this is a property of the government now.
Now, but section 10, that is why.
10 has got 10 will not be saved by 2 2. 10 has not got nothing to do with
Lordship,
2 2.
section 10, my limited understanding, my lord. Section 10 of the Provincialization Act says that best.
What is the saving clause? Saving clause is a things done
Yes.
before the repeal.
Yes.
It is in all repealing act. There is a saving clause.
Yes.
Because otherwise, if it is given, the repealing act is given a retrospective effect, everything will be null and void.
A saving clause, my
Saving
interpretation
clause is
that-
only for prospective
Yes,
operation.
but what I am suggesting, my lord, section 10, the building.
Yes, who will appear? Let her come.
Ms. Pidas will appear.
After a while.
Lordship,
May not have a case. What is the impugned order here?
Lordship, there are 3, my lord. Basically, first one is that
Page?
page 28.
28.
28 is a type copy, my lord.
Yes.
It was issued by the Director of Secondary Education to the principal, headmistress.
What kind of premises you are having in the school campus?
It's in the boundary, man, not in the premises, but
What?
one is a tire shop, one is the,
How can you have in a school campus?
because prior to
Even
it,
if you go by equity, you will look, how does it justify to have some establishment in a school campus?
it is not sharing the outside border only, my lord. But they can be evicted only by the procedure established under the Urban Areas Rent Control Act, my lord. In the event, in any case, my
Inside
lord.
the premises, there is a scooter garage and pan shop is also there. my
One shop
lord.
we are not having, my lord.
And
But my limited case is that if
Typical
petitioners are to be
procedure also there.
evicted, the procedure mandated under the Assam Urban Area Tenancy Act has to be followed, my lord.
and
I am not
mechanical
saying
shop
that
also
the
there.
petitioners are not evictable tenants, but the mandate of law is that Urban Area Rent Control Act, Section 5 provides the procedure, my lord.
Mr. Chakraborty, you are in a red jurisdiction.
Lordship. I understand, my lord.
Where will equity go for a toss? Come up in an appellate, invoke the appellate jurisdiction,
No, my lord,
go for
equity,
a suit, get a decree that you cannot be evicted without following the due process of law.
no, if they want to evict, my lord, equity,
So why didn't you go to the civil court?
it is for them to go, my lord,
Why?
because they want us to evict, my
Why
lord.
do you come here? Have they taken any coercive action to remove
Because
you
they-
forcefully?
Yeah, they wanted, because that,
We'll at best give you liberty to approach the civil court. Writ jurisdiction, equity will have
my
play a
lord, in the
major
event
role.
of any conflict between my respectful submission, my lord, in the event of any conflict between equity and law, this law will prevail. Law is that once there is a landlord-tenant
You
relationship.
invoke this law in a civil court, not in a writ court. Even civil court will have the equity
Yes,
provision.
yes.
But in a writ court, equity is of paramount importance.
If Lordship grants me that liberty, my lord, then
Obviously, you cannot be left remediless. You will have
yes,
some
yes, yes.
remedy.
In that case, well, I'm eligible, my lord, if your lordship disposes, my lord, disposes.
First thing is that get a decree that you cannot be evicted without following the due process of law.
Granting
Matter
liberty
ends
to
there.
approach the appropriate civil.
Matter
court, my
ends
lord.
there. And in fact, you cannot be.
Yes.
That much, any court will say that.
My limited case, my lord, in this
But
petition.
we are in a writ court.
Yes, my lord, my limited case is that once
Yes,
there is a
let her come.
lordship, lord.
I think for.
My lord, here in this, on the last occasion only, my lord, what was passed for my name, my lord. I came in the picture, my lord, for this tribal affairs department, my lord. My lord, so it's a 2016 matter, my lord. I need to file an affidavit. This is, my lord, matter pertains to, my lord, caste certificate. Somebody's scheduled tribe status has been taken away by this state level scrutiny committee. My lord is aware of the entire procedure, how it is done, man. So if I have to bring the record or I have to file an affidavit, man. Without that, my lord,
Madhuri Patil has been followed.
yes, he was there, my lord. He appeared. So, my lord,
What are your grounds?
Here, my lord, so far factual aspect is concerned, we are not disputing. So there is no question of filing affidavit because we are not contradicting their contention. What is the fact? It is fact.
So what are your grounds of
My
challenge?
ground is that, my lord. Here, your lordship kindly peruse. Page 27 is the order impugning this.
Passed by whom?
state level scrutiny committee.
State level committee.
Okay, 27.
Page 20.
Yes.
Here the case is that, my lord. By this impugning order, my lord, the caste certificate, individual caste certificate, issued to the father of the petitioner and to the petitioner. Both certificates are cancelled. The petitioner has challenged only his cancellation,
Okay.
not the cancellation of his father. My lord, kindly note it. This is my first point of argument. I have not challenged.
How is it an argument? This is not an argument.
Yeah.
This is a factual clarification
Yes.
that you are challenging your
Factual.
case. That you can challenge only. You cannot challenge somebody else's.
I
That
have
is not an
not-
argument. What is your argument? What are your
My
grounds?
argument is that petitioner's father, he was originally belonged to Nepali community. He was adopted by a Bodu man,
Who? Petitioner.
petitioner's father.
Okay.
After adoption, he married a Bodu woman. Petitioner is born out of from the home of a Bodu woman. Marriage between father and a Bodu woman. The certificate was cancelled on the ground that the adoption of the petitioner's father was not valid because the adoptive father, he had his son killed and accident. These are the issues. So this is there. Here, my only contention, I am relying upon one citation, Mike, that the petitioner, since born from the womb of a Bodu woman, and since he has adopted the Bodu culture, therefore he is entitled. Because he never adopted the culture of Nepali community. He never went to the community of his father. So he all along, since his birth till date, he is adapting and he is holding the Bodu culture. Therefore, his caste certificate, he is entitled to the facility of a Bodu community. On that ground,
Mr. Dhar, that consideration does not appear to be there in the impugned order.
Yeah, that is there.
What Mr. Udin is submitting, that has got some legal grounds
Yes.
that how you are brought up. The father's caste may not be the sole factor.
Yes.
It will have a bearing,
Yeah.
but mother, he says, belongs to the ST community. Then it is the claim of the petitioner. It may not be correct that he was brought up in a community, ST community, and brought up as an ST in the same environment. Now, whether it's correct or not, there has to be some application of mind. This order does not reflect that.
And-
This order has proceeded on the presumption or on the direction that father's adoption issue was not legal. Father is not a ST, so therefore son is not an assistant. That may not be the only, you can, I think you need to apply fresh.
And I am relying only one citation.
No, there are citations, you may be correct.
My lord,
Where is your, did you file any written statement?
Yes.
Where is your statement that you have been brought up? You cannot invent a ground in the writ court.
Page 21.
Mm. Twenty-one, yes.
Para 4, 7, 8 and 9. First para 4.
The-
Fact is that the original, page 23.
Yes, yes.
That the original natural father of Raju Buru, late Chandra Bahadur Rai, was belonged to Nepali community, whose original residential address was not known. Perhaps during the year 4950, late Chandra Bahadur Rai joined in the Defense Department, Government of India under such and such, who got retirement from his service during 80s. His service during late Chandra Bahadur Rai got married with one Putuli Rai, and out of their wedlock, 2 children, Sumitra Rai
What is your name?
and Raju Rai. Raju Rai, my father.
What is your name?
My name is Bikram Bodu.
Bikram, okay.
Raju Rai were born, and as such, he kept his family at Happy Valley
No,
BSF
no,
camp.
those are not required. We want to bring, read us those averments which relates to your upbringing.
7, 8 and 9. That during during the year 97, extensive revision of voter list was prepared, and the time of enumeration of the enumerator
But it's
one.
nothing to do, 7 is nothing to do with your upbringing. Where is your upbringing that you are,
Paragraph 8, my lord, from me. On retirement from service, actually specific,
there is no averment.
is he has argued the adoption of his father, my lord. But
No, there is no averment. You cannot just invent a ground in the writ court. The judgment which you are relying, Mr.
I am relying the judgment, my lord, it is
There is an Andhra Pradesh
Ramesh
judgment.
Bhai,
Ramesh Bhai is there, and there is an Andhra judgment also, which first laid down. But that is not your case.
Ramesh Bhai will go against him.
Ramesh Bhai, there is a two High Court division benches. One is from our High Court, one is from Mumbai. That has been had. If the culture, this is a fact, man. If the culture is,
No, you have to, that has to be a pleaded position.
that is unfortunate, my lord. This
If it-
specific pleadings is not there.
If it is not there, how do you
But this
invent
is
a
a fact.
case? How do you invent a case? Same thing, if Gorzanda said applies for an affidavit, it also applies for a writ petition. You cannot invent a case.
May I pray for remanding victim matter for my lord?
Why?
So,
You,
This much
if
opportunity.
you have taken a ground, not taken, overlooked, ignored, or taken but not properly dealt with, then matter of remand, claim for demand may be justified. Now, we cannot give you a chance to improve your case. What you are arguing now perhaps would have been a good ground for
Of course,
adjudication.
But unfortunately, that
Your advice was not taken at that time.
Not-
Where were you? You should have been there with the client.
because that was not drafted by any advocate. I am sure. my lord.
No, that was drafted by an advocate. It was drafted by an advocate. Mr. B. Rahman was there. Your friend. You see name of the advocate on behalf of the petition, opposite party. A. Rahman, Motiur Rahman, learned counsel from Borpeta. Page 21. In the written statement, also they made it specific that name of the advocate should be typed out. Do you get anywhere in a written statement advocate's name?
But this is the fact. Right? I am in fact not at the when I accepted the brief that and the matter was twice in the motion stage came up before my Lord Justice Goswami, my Lord, at that time. After the on third occasion notice was, that was the satisfaction. But I have never challenged that. Yes,
No, you might have had a ground. In fact, there are case laws.
yes,
Ramesh bhai, is there even there is an Andhra case which was perhaps one of the first cases
yes.
where this upbringing thing was
Yes,
taken into consideration.
Yes, my lord is in Navo Saronia, my lord is still.
Yes, yes.
But that is on a different context. That is not on the upbringing. That is on the investigation.
Here, my Lord, another case, that is KP Monu. Here, one paragraph I will. my
Supreme
Lord,
Court.
just-
Supreme Court.
No, Supreme Court judgment. KP Monu.
Please give the citation.
KP Monu versus Chairman Scrutiny Committee Verification of Community Certificate.
No, this
2015 4 SCC 1.
2015 or SSC 1.
Here,
Para.
para 18, there's some quotation in para 18. And I am just reading, the judgment is quoted.
Hmm.
That is CM Orumugam case, Smiler.
Yes, yes.
1976 1 SCC 8. Here, 32 of that case, Smiler. Another aspect which one must not forget is that when a child is born, neither has he any religion nor is he
That-
capable of
yes,
choosing
those,
one until
those observations we are aware. That is the background, in fact.
therefore on that ground, my lord, that case was designed.
Please hand over. And the earlier one, the first one, Ramesh bhai.
In fact, I have marked with red ink that
Doesn't matter.
I may be exonerated. So this is my case, man. Otherwise, factual ground I have no argument. And it is an admitted fact that adoption was not built.
Heard.
My lord, I will just correct 2 points, my lord.
Why are you arguing?
My
You want double dismissal or what? Who seeks?
the complainant.
Complainant.
Okay. Okay, doesn't matter. Okay. Please have a seat. An order dated 21/12/2015 passed by the Government of Assam, Department of Welfare of Plain Tribes and Backward Classes, whereby the caste certificate of the petitioner as ST was cancelled, is the subject matter of challenge in this petition instituted under Article 226 of the Constitution of India. Full stop. Para. The facts as projected in brief are that the petitioner is the son of one Raju Boro, who was originally belonging to the Nepali community. Full stop. However, the mother of the petition belongs to Boro community. Full stop. It is also the case of the petitioner that the paternal grandmother of the petitioner is also from the Boro community. Full stop. It has been averred that the father of the petitioner was adopted by a Boro family, and his father had also was also born in an environment of the Boro community. Full stop. The petitioner was accordingly granted a caste certificate, which was, however, the subject matter of a complaint lodged by the respondent number 6. Full stop. The said complaint was looked into, which culminated in the impugned order dated 21/12/2015, whereby the caste certificate has been cancelled. Full stop. I have heard Sri A.I. Uddin, learned counsel for the petitioner. I have also heard Sri R. Dhar, learned standing counsel. No, Tribal Affairs Department. Sri N. Das, learned state counsel for the official respondents. EF for Miss B. Sharma, learned CGC, and Sri G. Goswami, learned counsel for the respondent number 6. Para. Sri Uddin, the learned counsel for the petitioner, has submitted that while the impugned order dated 21/12/2015 the caste status as ST of both the father of the petitioner and the petitioner have been interfered with. Full stop. He has submitted that the present challenge is only with regard to the rejection of the caste status as ST of the petitioner. Full stop. He submits that the impugned order has proceeded on the presumption regarding the adoption of the father of the petitioner, who is admittedly from the Nepali community and was adopted by a Boro community family. Full stop. The impugned order has recorded that such adoption was not valid in the eyes of law, and therefore the impugned decision was rendered. Full stop. He has submitted that the aspect as to whether the petitioner was brought up in an environment of the Boro community was not given any heed at all. He has emphasized that the mother of the petitioner was from the Boro community and he was born in the Boro society, and this aspect has not been dealt with at all in the impugned order. Full stop. In support of his submission, the learned counsel for the petitioner has placed reliance on the following judgments: 2012 3 SCC 400 Ramesh Bhai, Dikhiba. Number 2, 2015 P. Manu. Full stop. The observations of the aforesaid judgments which have been placed, which have been relied upon, are extracted here in below. Extract code. Para. Per contra, comma, Sri Dhar, the learned standing counsel, has submitted that the projection presently made in this writ petition was never the case of the petitioner in the proceeding which culminated in the impugned order dated 21/12/2015. In this regard, comma, he has drawn the attention of this court to the written statement filed by the petitioner along with his father, wherein the present ground of challenge regarding the process of being brought up has not been mentioned at all. full stop. He has submitted that the reasons cited in the impugned order are germane and appeals to a prudent person and therefore cannot be the subject matter of interference by a writ court. Para. 3. And thus the learned State Council as well as Ms. B. Sharma, learned CGC, have adopted the argument of Sri Dhar and has submitted that the writ petition should be dismissed. Sri Goswami, the learned counsel for the respondent number 6, has informed this court that his client has passed away. Full stop. He, however, adopts the argument of his colleagues appearing for the official respondents and has submitted that the complaint was filed bona fide. Para. The rival submissions have been duly considered. Para. There is no dispute to the proposition of law and principles laid down by the Honorable Supreme Court in the subject concerning the present writ petition. Full stop. In the aforesaid 2 cases of so-and-so supra and so-and-so supra, the aspect of the incumbent being brought up has been emphasized, and it has been laid down that the said aspect would be a relevant aspect for taking into consideration while determining the caste status of a particular person. Full stop. Para. What is, however, intriguing is that in the written statement which has been annexed as Annexure 4 in the writ petition, the aforesaid aspect of how the petitioner was brought up has not even been mentioned. Full stop. There is not even a whisper as to on the aspect that the petitioner was brought up in the community, in the Bodo community, and by all means should be treated as belonging to the Bodo community and therefore was entitled to the caste certificate which was issued to him. Para. It appears that the following aspect has only been taken up in the writ petition, which finds mention in, where is your paragraph? Even in the writ you have not taken up. In the argument.
Five and six, my lord.
No, 5 and 6 where?
Paragraph 5.
No.
That the Raju Bodu married.
No, we have seen this. This is not the thing which you are arguing and which is required. The pleadings in the writ petition are also lacking on this aspect, and only in the oral argument this point has been taken up. Full stop. Para. The scrutiny by a writ court in exercise of powers under 226 is only on the decision-making process and not on the merits of the decision. Full stop. In the instant case, the impugned order dated 21/12/2015 reflects that the points which were taken up in the written statement have been duly dealt with and answered, and the
Paragraph 14, my lord.
14.
Paragraph 14.
Which is that? Which part of 14? We have read it.
First two line, my lord.
Please read.
That even if the father of the petitioner considers adopted son of Bodo.
It's a natural, that we know. Your mother is a Bodo, your upbringing.
Yes.
KP Manu. কি করলো লাস্ট ওখানে? Answered. Full stop. The conclusion reached by the committee, which appears from the impugned order dated, committee in the impugned order dated 21/12/2025 appears to be reasonable and transparent. Full stop. In view of the aforesaid observation, this court is of the opinion that the present may not be a fit case for interference, and accordingly, the writ petition stands dismissed.
I'm obliged.
Mr. Udin, you can take this back, not today, tomorrow, okay? Why, there is some thumb impression also. You want to use this as an affidavit or what? দুটা কোড করে দিব লাগিব। Yes, Madam Das. What is this?
Lordship, we have taken our stand very clearly, Your Lordship, in our affidavit in opposition, which we have filed
Which date?
on dated 4 April 2025 itself, Your Lordship. Your Lordship, page 39 onwards, paragraph 4.
What is their case? Have you understood their case?
Yes, Your
What is their case?
agreement is there, Your Lordship, in the premises of the school campus, Your Lordship.
Then,
But Your Lordship, due to some, Your Lordship, disturbances, Your Lordship.
no, those are factual things. What is the legal ground which she has taken? Have you understood that? You have to answer that. He has drawn the attention of this court to the 95 Act, whereby the madrasas were provincialized. And there is a clause, there is a section where the property would still vest with the madrasa. Okay. Now that act was repealed in the year 2020. And in the repealing act, there is a clause that whatever act has been done, those would be saved. It's a saving clause. He is trying to contend that the land and property still belongs to the madrasa, not to the government. And he is a bona fide and valid tenant, which started with an agreement with the managing committee before it was provincialized. So therefore, you cannot evict him without following the due process of law. That is his argument in brief. What is your response to that? Facts, we are not too much concerned. How do you respond to this?
Earlier dated, Your Lordship, when the matter is listed before Your Lordship, just Honorable Justice Debashis Borwa, Your Lordship. Your Lordship, on that date, that is 25/11/2024, which I have already annexed it in page 45.
Yes.
There is a clear direction is that I would like to read it, Your Lordship, that order, page 45. Pursuant to the directions passed by this court on 2011/2024, MS P. Das, the Learned Counsel, appears on behalf of the Secondary Education Department, Government of Assam, and places a communication before this court issued by the headmaster in charge, Guwahati High School, to the inspector of school, Kamrup Metro, Guwahati. However, this court has specifically directed the inspector of schools, KDC Pan Bazar, to place the report. And in paragraph 2, accordingly, this court fixes this matter again on 29/11/2024, on which Ms. Das, the Learned Counsel, shall place before this court the report so sought for. In addition to that, in the said report, it has to be categorically mentioned as to where the location of the petitioner shop and shops are
and what is the business being carried out by the petition. So as per your lordship, this direction, your lordship, I have categorically stated in our affidavit, which I have, your lordship, stated in page 41, that is of our paragraph 7, your lordship, that the petitioners along the shops carried out, your lordship, under the table form, your lordship, that is headed from 1, 2, 3, 4, 5, 6, 7. 7 petitioners were there.
We are concerned with three. There are three.
Your lordship, as your lordship, all the campus inside shops, I have to give categorically stated, your lordship. So I had stated it, your lordship. Your lordship, that Joni Medi, that is Joni Sensation, that is a scooter garage, then pertaining to
It's not Joni, it's June.
Jone Medi, your lordship. And then Montu
It's
Purva.
June or Joni?
Don't
June. Don't make June, Joni.
Then Montu Purva, MS Purva Tires, then Mohammed Abdul Rahman, that is New Vision.
Who, there are 3
Optical.
petitioners. Who? June, Mantu and Abdul.
Three petitioners.
And New Vision Optical carried out by
June is
Mohammed.
petition number 1.
Abdul.
Mantu is petition number 2. Abdul is petition number 3. Okay. Yes.
Then your lordship, I have stated that how it has
There are
been.
2 pawn shops.
It
Pawn
is
shops, 1 mechanical shop.
Pawn shops, 2
Pawn
pawn
shop.
shops were there, then mechanical shop were also there. Then your lordship, harmonium, tabla, etc. And it is inside the campus, and that creating disturbance towards the students, your lordship. So I have, your lordship, on earlier order, your lordship, I have clearly stated that I have to give categorically stated that what your lordship shops they were carried out. And basis on that, your lordship, if it creates trouble towards the environment of the school, your lordship, basis on that, your lordship, that matter will be closed, your lordship, dismissed, your lordship, as per the earlier order dated, your lordship.
Where is the indication? Is there any such indication in the order?
I think no in such.
It was verbal, your lordship, so that's why, your lordship, I have clearly filed this.
Madam, that is
affidavit
not the
stated.
case. It is not a case that some on the vicinity there are shops creating disturbance. That is not the case. Your case is on a much better footing. They are in your campus, whether it's a pawn shop or restaurant or anything, whether it can continue inside the premises of a government school. That is your case. You have to argue on that. What they are selling, that is besides the point. You have taken up the point that they are selling cigarettes and gutkas. Those are not the point at all. Point is whether they can exist. Whatever shop, tomorrow they'll say that we'll not sell gutka, we'll sell something, we'll have a bona fide business. Will it be allowed? The nature of the business is not the issue involved. Issue involved whether they can possess or this tenancy can be continued, if at all. What is your argument on that?
Your lordship, paragraph 5, your lordship.
Of your
Page
affidavit?
Yes, your lordship, page 40, your lordship.
40.
Yes, sir. I'd like to read.
Yes.
That the answering deponent humbly begs to state that as per the honorable court direction, a letter was sent by the DSC, that is Director of Secondary Education, here, your lordship, respondent number 2, referring to submit detailed report to the inspector of school, Kamrup Metro District Circle, by date so and so dated. Your lordship, that annexure I have annexed it at 46, page 46. And paragraph, point number 2, your lordship. Annexure to page 46.
Any commercial shop is
In-
not permissible in the premises of an education institution. That is your point.
Yes, your lordship. Installation of commercial shop will hamper the educational atmosphere of an institution. 3. Then 4, your lordship, coming to 4. Therefore, in the greater interest of the students' community, the petitioner Vice Street, John Methi, and others cannot be allowed to continue commercial shop in the premises of Guwahati Madrasa High School, Polton Bazar, Guwahati, and as such, their claim is found liable to be rejected, your lordship. And thereafter, your lordship, to that, your lordship, paragraph 6, that is on again page 40. I'd like to read it. That the answering deponent humbly begs to state that in this connection, a letter number so and so was received by the Inspector of Schools, Kamrup Metro District of Circle, Panbazar, Guwahati, whereon dated 21/11/2024, a forwarded application in connection with removal, withdrawal of shops situated within the campus of Guwahati High School, Paltan Bazar, Guwahati 1. It is also stated that the headmaster in charge of Guwahati High School informed that there are commercial establishments which are running within the campus of the institution, for which it is harming the school environment due to ongoing daily hustle bustle, which causes distraction towards the school environment. It is strongly not in favor of those shops which are situated within the campus of the institution. These are all commercial establishments which are running within the campus of the institution and thus disrupting and polluting the academic atmosphere of the institution, which I again annexed as Annexure 3, your lordship, at page 47. This is from Inspector of the Schools, your lordship, to Director of Secondary Education. That immediately an application has given, your lordship, for removal, withdrawal of shops situated within the campus of Guwahati High School, Paltan Bazar, memo letter dated so and so, that is issued on 21/11/2024.
Okay, yes, Mr. Chakraborty, we will narrate the facts in brief.
So just finally take note of my rejoinder, my lord.
No, first let us take note of the facts. Agreement, initially there was an agreement.
Yes, my lord.
Which date?
Lordship, at page 16, type copy, it was
Date.
it is on the last line, my lord.
1969.
1969, 2nd of June.
Agreement between whom?
Father of the petitioner number 1 and the then school managing committee, headed by the principal, headmaster. Father, please.
Father already.
What about the other petitioners?
Other, my lord, at page 20 is the petitioner number 2, first day of November 1995. It is with the school managing committee with Abdul Rahman, petitioner number 3.
No, 20 is page 3. Petition number 1 is page?
Petitioner number is page 16 is the type copy, my lord.
Okay.
And page 18 is the original.
And 20 is what date? 95.
Is first day of November 1995.
With petitioner 2.
With
petitioner 3. And what about 2?
2, lordship, kindly turn to page 25. I have made a specific statement, my lord. It continued since 1971. That statement, lordship, will kindly see.
25.
Paragraph 5.
This is between whom?
It is a renewal with the petitioner, which continued with the father. Renewal I have annexed at page 25. It is the renewal of tenancy, my lord.
Renewal with Basanta Borua. Bantos.
Bantos.
Here is Mantu.
No, Bantos elia Bantu, my lord.
Huh?
Bantos. Elias Bantos, my lord. Mantu Borua, Elias Bantos Borua. Post title, lordship, may kindly be seen.
Montu alias Bantus.
Yes, my lord. It continued since 1971, my lord. That specific statement at paragraph 5.
What is the date of this renewal? 1996.
Yes, my lord. 10th April. But it originally continued since 1971. Page 6 and 7. MS Borwa tires.
Okay. Then thereafter,
Thereafter, my lord, at page 28, the Director of Secondary Education issued a communication to the headmistress. Madam, it is learned that there are commercial shops running on the premises of your school. There are commercial hoardings too on the school campus. Thus, commercialization of school campus is not permissible and against our policy. In this regard, you are directed to inform whether you are receiving rent from such commercialization, who allowed this and under whose authority. You are directed to move district administration for their removal. Also remove the hoarding immediately or else and pay of entire staff will be held up. Pursuant to this, my lord, they have taken a resolution at page 30.
yes,
Lordship has got it, my lord.
yes, date,
Lordship, it is dated 25th of June 2016.
where do you get?
Lordship,
Where do you get the date?
Lordship, next vernacular, my lord, page 31.
25/6.
Lordship has got it, my lord.
Yes.
May I read, my lord? Pursuant to letter number so-and-so issued by the Director of Secondary Education directing to inform the district administration to remove the shops and hoardings from the school premises or otherwise, the salary of all the teachers and employees would be stopped. It is resolved that today's meeting that notice would be served upon the tenants. Lordship, kindly note, they have admitted us to be tenants, my lord, to vacate their possession within a period of 2 months from today, and if the shops are not vacated within the stipulated period, SMDC will be bound to inform the district administration for their eviction. My lord, here, my lord, my contention is that the role of district administration will come once they are unauthorized occupants, my lord. If your lordship এখন আছে volume 18.
Yes, what you want to show?
So what I wanted to show, the role of district administration will come once it is established that their petitioners are unauthorizedly occupying that property, my lord. Rightly or wrongly, my lord, prior to regularization, provincialization, tenancy agreements were executed. Lordship, Assam Public Premises Eviction of Unauthorized Occupants Act 1971 empowers the district administration to evict. It is in the local acts, my lord.
What is the name of the act? Assam Public.
Yeah, Assam Public Premises within bracket Eviction of Unauthorized Occupants Act 1971. This act empowers the district administration to evict from premises if they are occupying without any sanction or authority under law, my lord. That act, my lord, my respectful submission will not be applicable because here a specific direction is given to the district administration. The role of district administration will come. My submission is that only if they are unauthorized occupants. Here, my lord, the petitioners are not unauthorized occupants, my lord. Prior to the provincialization of the act, rent agreements were there, and section 10 of the act protects that, my lord, the land will continue with the madrasa, meaning thereby the agreements which were executed, it's still with the madrasa only, my lord. That is my limited case. And if they have to be evicted, Lordship, Assam Tenancy Urban Area Rent Control Act, it says, my lord. My case is that only it can be evicted by following the process which is mandated under Assam Urban Areas Rent Control Act 1971. Section 5, my lord. Section 0.
But who will invoke this act?
Lordship,
Who will invoke this act?
because on two grounds, my lord.
Who will invoke this act? This act can be invoked
Just
either by
SMC
the,
can evoke.
either by the tenant or by the landlord.
Yes, but if they want to evict us,
No, who is the landlord now?
we are the tenant. But
Who is the landlord?
landlord is the SMC, my lord. Because
SMC of a provincial high school.
no, my lord, because section 10, my lord.
Submission is not, we cannot accept that. The saving will not.
No, my lord, section 10.
First, so far as your first submission is concerned, that whether it's an unauthorized occupation.
Yes.
That might require some consideration, but
Yes,
your
madam.
second submission, that one has to take recourse to the Act of 1971.
No, my lord, what my,
Urban areas.
no, my lord,
that, will be
my
difficult.
remitted respectful submission, subject to correction,
No,
my
Mr.
lord.
Chakraborty, see, this it need not be elaborated in details. Section 5 gives the tenant the rights, the limited rights. You
Yes.
cannot be evicted.
Yes,
This is qua a landlord, not regarding anybody else.
yes.
Now, the question will arise, who is the landlord? Is there a landlord? You fall back on the provisions of saving clause.
Yes.
That landlord read with the last, that madrasa.
Yes,
Now, the saving clause, it only saves actions which were taken earlier.
yes. Earlier, we are
Now,
continuing.
will you get the benefit of a continuation? When those agreements have expired, they spent its force. You are not a tenant at sufferance. There is no landlord as now. If at all the concept of landlord comes, it is the government. Government is not a landlord in your case.
Because-
There is no tenancy with the government.
Yes, otherwise, my lord.
Government can lease out.
Yes,
That's not
that is what I am about to say, my lord.
there is no-
There is no bar on the government to lease out any premises.
But considering that it's a school,
Yes.
you are having a tire shop, a pawn shop.
Pawn shop we are not running, my lord.
No,
That-
somebody,
Yes,
the same
that
thing.
is not the case.
One tabla shop. We are not on the nature of the
Yes,
business,
yes.
but it is in the premises of a school campus.
That is there, my lord. But thing is that rightly or wrongly, in prior to provincialization, my lord, they executed. Because at that time, in order to meet up their expenses, probably that was the reason. And that is the reason perhaps section 10 was incorporated. Because knowing fully well, my lord, section 10 kindly be seen, my lord, for a moment. Because
The section 10 we have seen. Section 10 would have remained, but after
because, my lord, why, my lord, if your lordship sees the legislative intent for incorporating section 10, my lord. It is
Please.
not in other institutes, my lord.
300 page, 300 and
398, my lord. In any other provincialization act, lordship will not come across such kind of a provision, my lord. It is only in respect of Madrasa Provincialization Act, my lord. Because, my lord, those institutes, prior to provincialization, all the expenses were borne out of these rental incomes only, my lord. That is the legislative intent for incorporating section 10.
The resolution which has made your lordship, that was like as the president SMDC Guwahati Madrasa High School. It's
And SMC, we have made parties. They have not come out and said that we are not tenant. Meaning thereby they have accepted us to be their tenants, my lord.
what role will the SMC have after the provincialization?
But still, SMC is still there, my lord.
SMC before the provincialization, SMC after the provincialization, there's a
Yeah,
huge
there's a role
difference.
vast difference.
There's a
I understand.
difference.
But
Before provincialization, SMC is the owner,
Owner.
almost the owner.
yes, yes,
After provincialization, their role becomes
Yes.
very minimal.
they're limited purpose. But
No, why
still, my-
should they? Just a minute. Okay.
the paragraph 12 of my rejoinder may be seen, my lord.
Select.
Ultimately, my lord, it's a matter of Article 21, 19 and 21, my lord. They are living their early livelihood from these shops only, having no alternative.
Okay. এইখন নালাগিছিল, এনেই দিয়ে নালাগিছিল, এইখন বুলি ভাবিছিল। Land, buildings, property. Okay.
But my limited understanding is that once there is a tenancy in an urban area, the procedure mandated under Urban Areas Rent Control Act has to be followed. Whether it is between the government and individual, person to person, my lord, in any case, one, it is an urban area and there is an agreement, there is a tenancy, the provisions of Urban Area Rent Control Act has to be followed, my lord. Without bypassing that mandatory requirement, my lord, therefore cannot be, I'm not saying I cannot be evicted, my lord. My limited submission is that the process mandated under law has to be followed.
Okay.
And the Assam Public Criminal says, as directed, district, that we have no application in that case.
That you have already argued.
Yes.
Okay. Yes, madam. Anything? What is your response?
Your Lordship, pertaining to that, Your Lordship, that act, Your Lordship, that section 10, he has, Your Lordship, drawn Your Lordship attention, Your Lordship. Pertaining to that, Your Lordship, I would like to file another detailed affidavit, Your Lordship.
Now,
Yes, this one is your
matter is of which year?
2006.
16, 2025, you expect this court will give you time to file affidavit. You become wiser when the arguments are at the
No, Your Lordship,
conclusion.
then, Your Lordship, I'm totally, Your Lordship, relying on paragraph, Your Lordship, 5, 6,
Page,
page 40 of
40.
our affidavit, Your Lordship. Yes, Your Lordship. That later, Your Lordship. Both the letters, Your Lordship. That later has sent Your Lordship by DSC, which is respondent number 2, and thereafter Your Lordship communication later, which has received from Inspector of School, Kamrup Metro, District of Circle, Panbazar. Your Lordship, that is which I already stated it by annexure 3, where it has categorically pointed, Your Lordship, 4 point, included 4 point is there, Your Lordship, stated in page 46, Your Lordship, annexure 2. That detailed report, Your Lordship,
Yes.
from the Inspector of School. Why, Your Lordship, his prayer should not be accepted and it should be liable to be rejected? 4 categorically point has already been stated.
Okay.
Since this is an educational institution and pursuing to that, Your Lordship, a commercial shop is not permissible in the premises of any educational institution. And it will hamper the education atmosphere of an institution. Allowing it, Your Lordship, that the commercial shop will hamper the educational atmosphere because of ongoing noises, hustle bustle is surrounded, Your Lordship. So there is a distraction towards the whole surroundings, Your Lordship, as it is the better sense we have to see for the student, better interest of the students, Your Lordship.
Okay.
But may I submit one alternative argument? In the event Lordship considers that petitioners be approached the civil court, Lordship knows, my lord, under section 80 of CPC, 2 months prior notice is required to be given upon the appropriate government if a suit has to be filed. Lordship will kindly consider that aspect and protect till the process, my lord. Alternative, that is my first argument will be, my lord, all parts 1, 2, and 3. Alternatively, my lord, my prayer is that.
What prevented you from filing a suit in the year
16
2016?
onwards,
My
then
lord, on
you
that,
file earlier, Your
because, my lord,
Lordship,
we are on the verge of eviction, my lord. Therefore, we had
No,
to.
you approach the writ court, it is okay. Thereafter, what prevented you from filing a suit? File a suit, inform the court, withdraw the writ.
In the Lordship knows, but under section 80 of CPC, in the event of.
Understood. You had got a interim order on the first day when you had moved the writ court. You
Yes.
know that the writ court is not the remedy. Maybe under compulsion or under urgency, you move the writ court. You in the meantime take liberty, take leave of the writ court, file a suit. Okay, we will consider.
Lord.
T. Chakraborty, P. Das, secondary education.
Secondary.
And the State Council, judgment is, hearing is concluded, judgment is, we'll consider.
Lord. Because, my lord, in that event, my lord, if they are evicted forcefully, my lord, prior to filing of the suit, it will make cause. 18, it can be waived. It's up to the court to decide whether they can waive or not. 82, there is a provision of waiver by the court before which the suit is pending.
Getting stated that if to be a it's also not the same thing.
From 2016 onwards, there is an interim, Your Lordship.
Or section 5 is
25.
applicable, again, is protection, is for the protection of the tenant only, my lord, not for the landlord. Section 5 is. I'm deeply obliged for giving me the
Let us-
patient hearing, my
yes,
lord.
yes.
I'm obliged.
Deeply obliged.
My pleasure, Lord.
Yes, yes, yes.
In this case, the petitioner is aggrieved by a
order dated 18/11/2017. Lordship will find in page number 30
Yes,
and
who is
extra
there?
5 of my
On the other side, Mr. Das, you are there?
6.
Yes.
Actually, Lordship, in cause this, Lordship, Mr. P. Decca and A.K. Sinha's names are reflecting for private
Who is
respondent,
Bideka?
respondent number 3.
No, no.
And if I correctly recall, Lordship, during pendency of this case, one lady advocate appearing for the Assam State Commission for Women, one lady advocate. I don't know her personally, but maybe her name is reflected in the order sheet.
Madam Bodlo, you are appearing.
One of the order maybe, I'm sorry, Lord, I couldn't examine the record.
Yes, no.
One lady advocate was appearing representing
Mr.
the
B. Deka. Who is Mr. B. Deka? Vibhushan Deka. Vibhushan, I think. No, he is B.D. Deka. Vibhushan Deka. Huh? Who? Huh? এইটো নেকি? Oh, Boidojjamani Deka. Boidojjamani Deka. And A.K. Sinha. These are all connected to chamber of Mr. K.K. Mohanto. Look, if they are not if they're not interested, then we cannot want J.C. Bora. Mr. J.C. Bora. Oh my God. Mr. Botak, what is your case?
First, the petitioner is actually by order passed by the Assam State Commission for Women.
Yes.
Annexure number 5, page number 30 of my writ petition. Madam.
30.
Yes. May I read the order? Madam? A small order.
Yes.
May I read?
Yes.
Both the complainant and the opposite parties are present. We have heard both of them. Having heard, we are of the opinion that opposite party should vacate the tenanted premises within 30th of April 2018 positively to avoid further problem or earlier. For the time being, the case shall remain pending with liberty to the complainant to approach us again. Further, we have not given any opinion on the allegation made against the opposite party. Same line is repeated again.
Oh, what is your relationship with the complainant?
I am the tenant and the respondent number 3 is my landlady.
Okay.
And what happened?
Now you are still occupying the
Yes,
place.
yes, because there is a title suit pending for filed by the.
Well, yes, who is Mr. Madam, you will be appearing for the government. I think jurisdictional.
Actually, the issue before this.
It's a jurisdictional error.
Yes, yes.
The commission cannot pass such an order.
Yes.
Rightly, there is an interim order.
Yes. And there is a.
Commission can do things which are prescribed by the law. They cannot direct eviction.
There is a judgment of my Lord Justice Amitabh Roy, sir.
No, it doesn't matter. We don't need judgments here. It is the law. What is the jurisdiction? There is a specified forum in a civil court
Yes.
for evicting, ejectment.
In fact, filing of this writ petition, after filing of this, she approached the civil court also. Now this case is pending there.
Pending. Okay,
Yes.
we allow this.
Evidence says.
We allow this. Mr. Das. Oh, where is Mr. Deka? Can you inform them? You to inform this. I think this order cannot sustain. Yeah, Women's Commission cannot direct ejectment.
Yes,
And Mr. Botakut has informed this court that in the meantime, the complainant has also filed a civil suit. Maybe properly advised. Now, this complaint was also maybe justified, but the direction which has been given by the commission for vacating the premises, that is, I think, in excess of jurisdiction. And rightly, there is an interim order.
Respondent number 3 already filed affidavit. Is on record.
What does it say?
Nothing Lordship against some allegation against.
No, we can, we'll allow this, but if you get Mr. Deka, you bring him.
Can it be taken on Thursday, my lord? In the meantime,
No, we just want to, because of formality, otherwise I don't think they can improve their case.
Yes.
This case has to be allowed. And their names are shown. If they are not appearing, we can still allow it. It's for hearing, isn't it?
Yes, yes, here it was.
Case of 2018, if they're not allowed.
Yes, it can be shown that
On
they are
last,
absent.
on last many occasions, they are not appearing, Lordship. Order, the Lordship may con-
No, Mr. Borthakur, the adjournments were on your behalf, not
Yes,
on
yes,
their behalf.
yes.
On your behalf.
Personal difficult, but they are not present. Whenever I appear before the court, we are not. They are not in a dispute matter.
Hmm?
Already package suit is pending and evidence.
আর কি does matter? এই দুটা কৰাৰ পিছত এইটো মাতি দিম. We will try to locate Mr. Deka. Okay, we'll have it after some time. We'll and finish the other two matters if those are taken up. Otherwise, try to contact Mr. Deka or Mr. Sinha. Item 8. Yes.
My lord, this case, my lord, petition are before your lordship with a lady, my lord. And she has a fair price top, my lord, having, my lord, 54, my lord, card. Even then, my lord, in the meantime, one, my lord, policy decision was taken that, my lord, any fair price top holder having, my lord, 50 or less card, my lord.
Will be
Fair-
attached.
Yes, my lord. There will be, my lord,
Okay, you are having 54. So what is your problem?
my lord, even then, my lord, it is, my lord, tagged with another nearby, my lord, top five. But if in this regard, in their affidavit, they have submitted one report, my lord, page 41, my lord. In their affidavit, my lord, one report is there,
41.
41, my lord, nectar
please.
C,
Hmm.
in their affidavit. my lord.
Yes.
B, my lord, regarding this petitioner, my lord.
Yes.
Rina Begum Loskor, P, FPS agent, FPS code number, so and so license number.
Exempted. Exempted.
Exempted, my lord.
Yes.
And
This is in your favor.
Yes, my lord, requested not to, my lord, take, my lord.
Yes.
And her name, my lord, and in the next page, number 1, my lord, Rina Begum, my lord, updated, my lord, 54.
Not tagged. Yes.
Not tagged.
What is your problem then?
Now, my lord, lastly, my lord, he has annexed, my lord, one document, my lord.
No, what is your problem then? It is not
Public,
tagged.
my lord, now, my lord, her copy is tagged, my lord,
Where?
with another, my lord, Yam Uddin, my lord.
Where is this? Which page?
Now, my lord, lordship kindly have a look. It is reduced, my lord, page 25, my lord, in my read petition, my lord.
25.
Page 25, my lord.
Yes, please.
Her name, my lord, at serial number 18, my lord. And suddenly, my lord, it is reduced to only one, my lord, card. Ration card 1. In the month of, my lord, June 2020.
Where is the tagging order?
Taking order, my lord, is not in their affidavit, my lord, page 34.
Yes.
is according to them, my lord, as per the status, my lord, second line, page 34, my lord. As per the status record, number of beneficiaries against the petitioner, FPS was only 41, but further record has shown that due to transfer of some beneficiaries to the petitioner, FPS, in subsequent period, the number of beneficiaries goes up to 54. This process of increasing the number of beneficiaries against the petitioner's fair price shop was not recognized by the Director, Food and Civil Supply and Consumer Affairs, Assam, as mentioned earlier. So the fair price shop of the petitioner was checked with nearest fair price shop of Yamuddin.
Is there anything to decide, Mr. Sharma?
Lordship,
Your affidavit in very clear terms
Yes.
at page 33 has
yes,
said
Lord. That is our stand, because initially, Lordship, that there should be more than 50.
50, yes.
They had 41, but
Yes.
it was increased to 54. As it was found that initially it was 41,
It was tagged.
Lordship, that is the reason.
Okay, now you can take action. Detag it. Okay, heard.
Or may I suggest, they have filed certain representation, as because they have 54, Lordship, I also,
No, depending on the affidavit, we'll
Lord,
pass orders.
Lord.
Otherwise, it'll all again increase one more step.
Lord,
Should take the burden ourselves. Why should we
Lord.
push it to somebody else?
Lord.
Yes, Mr. Borbia,
Yes,
repetition should be allowed or representation should be disposed of.
my lord,
Huh?
we allowed,
Representation.
no,
Heard 3 A.M. Borbia Learned Counsel for the petitioner. Also heard 3 H. Sharma Learned Additional Senior Advocate Assam for the official respondents. Para. As per the facts projected, the petitioner is a fair price shop owner under the Mongalpur Baoli Hawar Cooperative Society Limited in the district of Kachar. Full stop. The petitioner was duly issued license number 2747 and was allotted a fair price shop code being 131660 kuch hai number hai. What's up? It is contended that the petitioner was catering to the needs of 54 numbers of ration card holders. Full stop. However, by wrong application of a policy decision, the shop of the petitioner, the consumers of the petitioner were tagged along with another fair price shop. Full stop. Para. Sri Borbia, the Learned Counsel, has submitted that the policy decision applies to a fair price shop having less than 50 numbers of card holders, and the said clause was not applicable to the case of the petitioner, who admittedly had 54 numbers of card holders. Full stop. Para. Sri Sharma, the Learned State Counsel, has fairly submitted that the policy decision was applied as the data had revealed that the number of card holders was 41. Full stop. However, it was later detected that due to transfer of certain consumers, the number of card holders had increased to 54. Full stop. He has submitted that the aforesaid position has been clarified in the affidavit in opposition filed by the respondent number 3 on 23/11/2022. Para. the rival submissions, the submissions made by the learned counsel for the parties have been duly considered. Para. There is no dispute with regard to the validity of the policy which requires tagging of fair price shop having less than 50 numbers of cardholders to a nearby fair price shop which is done for exigency of service and convenience. Full stop. However, in the instant case, it clearly appears that the tagging of the shop of the petitioner was done on a wrong premise by taking the data as 41, which however had increased to 54. Full stop. In this regard, it would be note towards it would be in this regard, the averments made in the affidavit in opposition filed by the respondent number 3 are to be taken into consideration, which reads as follows, paragraph 33, paragraph 33, last ऊपर dot करके यहाँ 33, 34, यहाँ से यहाँ तक, यहाँ से यहाँ तक ऊपर dot कर दीजिए, हाँ ये पूरा दे दीजिए, dot कर दीजिए यहाँ से 33. This court is of the considered view that the stand of the official respondents being clear on the aspect that the tagging was done on the premises that the number of cardholders was less than the prescribed numbers as per the policy decision, comma, this court, comma, the present writ petition deserves to be allowed, full stop. It is accordingly, the writ petition is accordingly allowed by directing that the tagging, that the consumers which were initially tagged with the fair price shop of the petitioners be restored back. Full stop. The said exercise be undertaken and completed within a period of 2 months from the date of receipt of a certified copy of the order.
To be submitted by the petitioner.
Diploma.
That item number 2, most probably he is late for keeping that photo.
Okay, we'll have it day after tomorrow.
Day after tomorrow.
Day after tomorrow.
Today is Tuesday, Thursday.
Okay, we'll try.
The urgency is there because that.
Okay.
Interim order to.
Yes, yes. On a request made on behalf of Sri D. Nath, learned senior advocate Assam, the matter is adjourned to be listed on Thursday, 17th. Sri P.K. Rajchodhuri, learned counsel for the opposite party, writ petitioner, has however informed. Don't say it. On the prayer of Sri P.K. Rajchodhuri, learned counsel for the opposite party writ petitioner, comma, the interim order passed earlier stands extended till the next date of listing.
Matsu.
Okay. Are we to?
Until 6.
D. Nath, senior advocate, Dipankar Nath. It will name up to the Asil there. Yes, Mr. Bhattakur.
I told that he is not now associated with this case, so he informed.
I will allow this. Mr. Sharma, have you gone through the matter? The Commission for Women Commission has directed an eviction from a rented premises. That carries out excess of jurisdiction. But it will not say, and Mr. Bhattakur has informed that in the meantime, the owner has filed a civil suit.
That's the appropriate
forum.
Yes, sir.
Heard Sri P.P. Bhattakur, learned counsel for the petitioner, Also heard 3. H. Sharma, learned additional senior law advocate, Assam. Will you appear? See the area of parties, Assam State Women Commission. Will you appear? I think you can appear for the official respondents. For the official respondents. Footstep. Though the names of the learned counsel for the respondent number 3 has appeared in the cause list, comma, none is present. Para. As per the facts projected, comma, the petitioner. No, don't see. The grievance of the petitioner in the instant case is qua an order dated 18/11/2017 passed by the Assam State Commission for Women in ASCW case number 202 of 2017. Full stop. By the said order, comma, the Learned Commission has directed the petitioner to vacate the tenanted premises within 30/4/2018. Full stop. Para. As per the facts projected, the petitioner is a tenant of the respondent number 3. Will you appear? But will you appear or not? What is your name? Huh?
As Gautam.
As Gautam, huh? As Gautam for respondent number 3. Huh? इसको क्या होता? The said respondent number 3 had, however, filed a complaint against the petitioner before the respondent number 1 commission. Full stop. The said commission, by the impugned order dated 18/11/2017, had directed the petitioner to vacate the rented premises within 30/4/2018. Full stop. Para. Sri Bothakur, the learned counsel, has submitted that the aforesaid direction is absolutely without any jurisdiction, as no such powers are vested in the commission. Full stop. He has submitted that the petitioner is protected under the Assam Urban Areas Rent Control Act 1971, and if at all any ejectment, and is protected, and is protected, क्या बोला? Is protected नहीं बोला? More specifically, Section 5 thereof, and if at all an action for ejectment is required, comma, the appropriate forum is required to be approached. Full stop. Para. Sri H. Sharma, learned State Counsel, has fairly submitted that the aforesaid direction appears to be in excess of jurisdiction. Full stop. He, however, submits that he would not make any comments on the inter se merits of the allegation made against the petitioner by the respondent number 3, which is required to be proved in accordance with law. Mr. Gautam, anything? Oh, okay. Sri Gautam, the learned counsel for the respondent number 3, has informed that in the meantime, the respondent number 3 has in fact filed a title suit for ejectment, which is pending. Para.
His number is required. TS
Being TS
22218.
2018 in the court of
Civil Judge Junior Division 1, Kamrup.
Civil Judge Junior Division, Kamrup. Para. The rival submissions have been duly, no, don't say rival submissions, the submissions advanced on behalf of the parties have been duly considered. Para, this court has noticed that, has noted that while issuing notice, wide order dated 19/3/2018, this court had directed that until further orders, the impugned order shall remain suspended. Para. The powers to be exercised by the Respond Number 1 Commission have to be within the prescription of law as laid down in the relevant statute. Namely, what is the name of the statute?
The Assam State Commission for Women Act 1994.
Assam State Commission of Women Act 1994. Full stop. Though the commission is vested with certain powers with regard to the protection of women, the power of ejectment of a tenant is not vested with such commission, and such powers have to be exercised only in the process and manner prescribed by law. Full stop. It clearly appears that the direction contained in the impugned order dated 18/11/2017 towards vacating the premises has been passed in excess of jurisdiction, or maybe by overlooking the provisions of law. Full stop. This court has also noted that the Respond Number 3 has in the meantime instituted a suit for ejectment. Full stop. That being the situation, this court is of the opinion that the writ petition warrants merit, and accordingly the impugned order dated so and so, so far as it pertains to vacation of the premises by the petitioner, stands interfered with and is set aside. Full stop. The interference by this court will, however, not have any effect on the proceeding instituted by the Respond Number 3, which would be decided on its own merits. Para, writ petition stands allowed in the manner indicated above. This Women's Act will put some portion in the judgment, huh?